Hello, everyone. Thank you for joining us in our complimentary webinar series for U.S. federal government contractors. We are coming to you live today from Washington, D.C. You probably found out about today's webinar through our newsletter, which reaches over 23,000 federal government contractors and service providers. Today's session is complimentary and also recorded. You can find the recording on our website and YouTube channel about 24 hours after the webinar. We have over 525 complimentary webinars on our YouTube channel. This includes all 52 parts of the FAR and all 52 parts of the DFARS, as well as hundreds of webinars on strategic and tactical topics. If you would like to advertise in our newsletter or in any of our upcoming webinars, please email us at hello@jenniferschaus.com. A little bit about us. We are a specialized consulting firm focused on working with established federal contractors. We work with product, service, and software firms across the globe. For more information about our services, please visit our website and select About Us. As mentioned, today's webinar is covering the FAR supplements. It is complimentary and also recorded. We began this series in January 2022, and you can find these past recordings on our website, as well as future schedule and registration lists. As you can see here, we have covered several of the FAR supplements already, and we'll wind down the series on August 24th with the Veterans Administration. Then on Fridays, we cover the same agency or department in a Playbook series. The Friday webinars discuss upcoming bidding opportunities, contracting trends, small business resources, and sometimes feature a government speaker. The full schedule and past recordings are on our website under the Playbook tab. Please join us at the Kennedy Center for a night of networking with over 200 federal contractors. Our quarterly event will take place on Monday, June 20th. Sponsorship opportunities are available. Federal agencies will be present and will be listed as they confirm. Please note that ticket prices increase on June 13th. We hope to see you there. And now we would like to take a moment to thank our sponsors who help make the webinar series possible. We would like to thank the Virginia PTAC. The Virginia PTAC is based out of GMU in Fairfax and offers free one-on-one counseling to firms in Virginia on federal, state, and local procurement topics. Online resources and group trainings are free with no restriction on business location. If you're interested in learning more, please use the links provided to explore what PTACs can offer. And a special thanks to the Federal Business Council. The FBC creates and manages virtual and in-person meetings and events to connect appropriate industry and government thought leaders, product providers, and solutions with government programs that use them. The FBC works with mission-specific programs for a variety of agencies to connect government and industry in the form of in-person and virtual conferences, training events, policy dialogue, and outreach. Over the last 40+ years, FBC has become a comprehensive resource for connecting industry and federal government. Dastin is an IT and cloud solutions provider working with corporations, the military, and government agencies to lower their costs, increase scalability, improve operational efficiency, and meet compliance regulations using targeted cloud-based solutions. Dastin is a certified partner of Oracle NetSuite, a premier tier Google Cloud partner, and a certified partner of Cisco, Virtue, AO Docs, and Authenticate. For more information about Dastin services or to schedule a complimentary consultation, please email Joe Alston. His contact information is in the lower left corner of the slide. You can also visit the Dastin website. Thank you again to the attendees and our speaker for joining us today in our FAR Supplement series. We are here today to dig into the FAR Supplement on the Department of Education. Our speaker for today is Brandon Dobbins, and he represents the firm Taft, Stentinius, and Hollister. As a reminder, we do not take questions, so if you have any questions for Brandon, his contact information will be displayed at the end of the presentation, and you can contact him directly. Thank you, Brandon, for joining us today. I'll put myself on mute and wait for your cue for the next slide. The floor is yours.
Thank you so much. And again, this is Brandon Dobbins with the law firm of Taft, Stentinius, and Hollister. Taft is a full-service law firm in the Midwest, and as of this year, we are AmLaw 100. And so we have offices in 4 cities in Ohio, Indianapolis, Chicago, and Minneapolis. I'm based in our Dayton, Ohio office in our government contracts practice. So all I do is government contracts on a daily basis. prior to coming to Taft, I was actually Assistant General Counsel for a government contractor who conducted some contracts with the Department of Education. So this topic is very familiar to me, and I was happy to speak to you all today about it. You can advance this next slide, please. Sorry, I'm not seeing the slide advance. There we go. Perfect. So this is just a note that, you know, I am a lawyer, but I'm not your lawyer, so you should contact an attorney with any specific questions related to any particular problem or issue that you're facing. Next slide, please. So just a little bit about what I'm going to cover today. This is not going to be a comprehensive read through the entire Eddar, but we will go through an introduction, which will cover the structure and scope of the supplement, as well as some of the background of the supplement. The compliance obligations section will be talking about items which would need special attention outside of normal FAR-based compliance. This is going to be for like reporting, record keeping, those kinds of obligations. In the contract clause section, I'm going to cover some supplemental clauses that will affect performance outside of the normal FAR provisions in the 52 section of the Eddar. And then I will wrap up. Next slide, please. So the Eddar is broken into 8 subchapters listed here. Those subchapters have different parts within them. Not all of these numbered parts are in the range exist, but there's space left for, you know, those items if they were to add additional things in the future. This is a fairly short FAR supplement, and the meat of the programming is going to be about the general parts, the contracting methods, and some of the specific contracting requirements, and then of course the clauses and forms and 3452. The Eddar is 48 CFR, parts 3400 to 3499. So 34, and then your last 2 digits are going to be similar to where your FAR part would be. I'm not going to cover all the parts of the Eddar in this presentation. Please advance to the next slide. So some basic terms. Department of Education is known as ED to people who contract with it regularly. This definition is set forth in the Eddar as the preferred abbreviation of the Department of Education. FSA, one of the largest parts of the Department of Education, is Federal Student Aid. This is the part of the organization that has to do with all things student loans and grant funding for students. Another term that's used in the Eddar specifically is PBO, or a performance-based organization. This is the prior name of FSA that came from the Higher Education Amendments Act of 1998. Head of Contracting Authority, or HCA, this is an important definition for a lot of the compliance obligations and reporting obligations that you need to engage in if you're contracting with ED. This is the person responsible for acquisitions who has the unlimited contracting warrant. For FSA, the HCA is the Director of FSA Acquisitions. For all other offices within ED, the Director of Contracts and Acquisitions Management is the HCA. So you have 2 separate people depending on whether you're talking about FSA or the rest of ED. Definitions and acronyms are found in subpart 3402.1. Please advance to the next slide. So scope of the Eddar, it's applicable to all ED contracts unless the contract explicitly excludes the supplement. For non-appropriated fund contracts, you have to follow this to the maximum extent possible unless the KO decides not to apply certain clauses. It's meant to supplement and implement the FAR in order to meet ED-specific needs when they are contracting with outside parties. The FSA HCA is permitted to issue supplemental guidance applicable only to FSA, and Ed also issues deviations. I've left the link here for the deviations page. There's currently 6 deviations active, and 4 of these are on information security. So when you look at the deviations, you can tell, what the priorities are of things that haven't gone through the rulemaking scope. You can advance the next slide, please. Oh, and I will note that I've left citations to each part of the Eddar in italics at the end of a line when there's a direct citation to the point of what I'm talking about in each slide. Ratifications is an issue that comes up sometimes in FAR contracts, but may come up more often in Eddar-based contracts. If the contracting officer communicates something to the contractor that would constitute a modification, but doesn't officially issue a mod, this can be ratified post hoc by the chief of contracting office, or if it's up to $25,000, or the HCA if it's above $25,000. If the contracting officer communicates a commitment that would be subject to ratification, they would then need to seek approval of their manager, and then that manager would go to either the chief contracting officer or the HCA. Next slide, please. So now I'm going to get into some of the compliance obligations under the FAR. In addition to the normal contract types that everybody's used to, Ed has some specific things in their supplement that allow them to do additional types of acquisition. FSA, particularly, is allowed to conduct 2-phase solicitations, doing a general notice for phase 1, narrowing it down to phase 2, and advancing only those people that meet the requirements for phase 1 into the phase 2 section. Also, in addition to the normal cost reimbursement, time and materials, and labor hour contracts, Ed is also allowed to engage in cost-sharing contracts and incentive contracts. Now, with cost-sharing contracts, if the costs that are not reimbursed by that contract have to be paid by the contractor, they are not allowed to be charged to any other federal grant, cooperative agreement, contract, etc. Incentive contracts can be either performance or award term based. Award term is when there is a predetermined plan to allow for superior performance to increase the scope of the contract and to reduce it for poor or substandard performance. The contracting officer has to justify this and seek approval by the HCA before modifying the contract to expand or reduce the scope. Next slide, please. There are also additional business practices and conflicts of interest policies that need to be examined when you're conducting a contract with Ed. Ed has specific regulations on conflicts and standards of conduct in 34 CFR Part 73. And then there are specific reporting requirements if there is a violation of various FAR and other law violations that need to be reported. The gratuities clause of the FAR, if there's a violation discovered by the contractor, they need to report that to the HCA in writing, detailing the circumstances of the violation. If there is an antitrust law violation, you have to report through the HCA, who will then report it to the Office of General Counsel and the Senior Procurement Executive. For the covenant against contingent fees, if an Ed personnel discovers it, they must report it to the HCA. And then in order to overcome the prohibition in FAR 3601 on contracts with government employees, those must be approved directly by the HCA. Next slide, please. Debarments, suspensions, and ineligibility actions are covered by a separate FAR, Part 3409. The Senior Procurement Executive is the designated debarring and suspending official, and they can make decisions on behalf of Ed. If a contractor is proposed for debarment, you have to submit the additional information within 30 days of the notice of proposed debarment or suspension in order for it to be considered by the debarring or suspending official. Fact finding is conducted in accordance with FAR 94063 in debarment cases not based on a conviction or a civil judgment, and these other parts here in suspension cases not based on an indictment, if the contractor's submission of additional information raises a genuine issue of material fact. Next slide, please. The Eddar also has additional organizational conflicts of interest language. The HCA is again the designated official for waiving any rule or procedure of FAR 95. Contractors with potential or actual conflicts which can't be avoided are not eligible to be awarded and may have their contract terminated unless the HCA waives that conflict. These clauses are required in all contracts over the simplified acquisition threshold, and the contracting officer may also require certification of no OCIs below the SAT if the contract includes the language in Eddar 3409-570. And again, this is important to make sure you're following the OCI policy specific to the supplement that is in the contract. Next slide, please. So now I'm moving into some ED-specific contract clauses. And some of these are just for notice, making note that they're a little outside of the norm. Others are very specific to ED-based work. So the first one here is the printing clause. There are a lot of ED contracts that would require a significant amount of printing, so making sure you're requiring with this unit compliance is an important thing to do. So there is a ban on printing in connection with the contract unless there are less than 5,000 units of a single page or 25,000 units in the aggregate of multiple pages. And a unit is one side of one sheet of paper, single color. Each additional side counts as another unit. Each additional color counts as another unit. So if you have two colors on two sides of paper, that's 4 units. So that's just a thing that could catch people up. If you're doing a contract, say, where you're mass mailing students on behalf of FSA, you're going to have specific language in your contract to overcome this printing clause. Again, also, important, especially with FSA, is Paperwork Reduction Act. If you're collecting information for use of disclosure by the government of 10 or more people, you have to get the Chief Acquisition Officer's clearance before you do that. And this also has to go to OMB. And the clause says plan for a minimum of 120 days to obtain the necessary clearances. That is probably pie in the sky thinking, but any delay beyond that may be considered excusable by the government. Next slide, please. The conflict of interest certification, which we discussed a little bit ago, in acquisitions above the simplified acquisition threshold, you have to certify to the best of your knowledge and belief that no personal or OCI exists or could exist for employees, staff, and contractors. And this is the same general 3 bases of OCI: unequal access to information, biased ground rules, or impaired objectivity. Next, a clause, there's a couple here in a row, about FOIA. Restrictive legends do not necessarily have force in contracts with the Department of Ed. Offerors have to acknowledge and agree that the government's not liable for any disclosure, even of information that contains a restrictive legend. Proposals that contain legends that aren't in compliance with FAR 52.215.1 or take exception to the Eddar clause can be rejected as non-responsive. Next slide, please. And again, without regard to the proprietary markings, the Department of Ed can release information in response to a FOIA request, including without limitation, and then basically everything under the sun is what's included in the clause. In practice, I would say this doesn't happen as often as it would seem like it, based on the fact that they have two clauses back to back telling you about it. But it is important to note that they do have these clauses in there, and it could be subject to release without any attempt to propose redactions like normal contracting. These next few clauses are going to be about research activities. Primarily, these are going to be universities or other higher education contractors that are going to be involved in these. The first here is about activities involving human subjects. Contractors are required to establish and maintain procedures to protect human subjects consistent with the regulations in 34 CFR Part 97. This must at a minimum cover the following 7 items: human subject involvement and characteristics, sources of materials, recruitment and informed consent, risks, protection against risk, the importance of the knowledge to be gained by the research, and what sites are collaborating in the research. Next slide, please. And as a follow-on to that, there is a clause which requires compliance, including the requirement to institute approval and review by an institutional review board for any human subject-based research activity. This is fairly standard in this area of research anyway, but it's just a note that it is a requirement of the ed contract that you do that. And then the next clause on the list here is the publication and publicity clause. Unlike other government contracts, Ed wants you to publish and promote the results of the work when it's funded by Ed for research. When the work's submitted for publication, though, you need to send a copy to the contracting officer's representative. The Corps also needs to be informed when the work is published and be sent a copy of the published work as soon as possible. In the publication, there is a required acknowledgement of the support received from the Department of Education. That specific language is set forth in Eddar 3452-227-70B. Next slide, please. Everyone's favorite topic, data rights here. If there's any government data or software that's going to be provided to employees under the contract, an NDA in the form that's specified in Eddar 3452-227-72C has to be executed by each recipient. I know when we had information in our ed contracts in my former employer, every single employee that was on that contract had to execute an NDA. They're also making sure you're following the limitations on use or disclosure on any restrictive legends that would come in any government data. There's a specific clause here at 227-73 that all restrictive legends must be complied with, and the contractor agrees to indemnify the government for any breach of these restrictions, and you may be subject to suit by any third-party rights holder or beneficiary. So if someone develops some commercial software or some government software that would be used by you under another contract, and you cause that intellectual property right to be breached with respect to the restrictive legend, this clause specifically allows that third-party rights holder to sue you, and the government is indemnified if there is any suit against them. Next slide, please. Required insurances. The contractor is required to procure all insurances as required by law, such as those set forth in FAR subpart 28.3 at coverage limits set by the contracting officer in the solicitation. So unless otherwise approved, you do not procure coverage for any government property as the government is self-insured. Additionally, the department has security requirements in several of its operative clauses. Contractors, their employees, and subcontractors must comply with all ED requirements when accessing an ED facility or information system. These are secure. There are security risk levels set forth in these clauses, and they require screening of employees, background checks, that type of thing. All employees working on ED contracts must be either U.S. citizens or lawful permanent residents, unless there is a non-applicable, unless the security requirements are non-applicable or there's a waiver of some kind. Next slide, please. Litigation claims, this is another notice requirement that if there's any litigation filed against the contractor based on its performance of the contract, or any claim against the contractor for an allowable cost under the allowable cost and payment clause, the contractor must immediately notify the contracting officer in writing. With that notice, any copies of any documents related to it must be sent. And if required by the contracting officer, the contractor must assign and subrogate its rights and claims except as to against the government arising out of any such claim for the government to take care of, any action it needs to take as a part of that. Additionally, there is a notice of delay required. So under many FAR-based contracts, there are delay clauses. This one specifically says that in the event of an actual or potential situation which will cause or threaten a delay of performance, you must timely notify the contracting officer in writing with all relevant information. Timely is going to be a very situational dependent item here, and so whether that is a day, 5 days, is going to depend on the circumstances. The best rule of thumb is if it's something you think is going to cause a problem, you need to let the contracting officer know in writing and supplement that as you go forward. Next slide, please. So in conclusion, Eddar is really one of the shorter FAR supplements. Most of the requirements that are going to be inserted in these clauses are going to be contract specific, depending on the subject matter and operational procedures in the contract. Pay attention to operating thresholds because some of them are limited to the simplified acquisition threshold, et cetera, and depending on the work you're doing, that may or may not be applicable. Also, note that there can be deviations issued, and then as I mentioned before, FSA is allowed to issue specific rules related to its procurement, so you want to check, make sure that there have not been any deviations that apply, that would apply to the contract that should be included or are included, and note that there are several outstanding cybersecurity class deviations, including one that's fairly significant that's not quite CMMC, but very, very close. And also, the other thing important to pay attention to for ED is their ED-specific timing for reporting and other notices which need to be provided to the contracting officer under the contract. Next slide, please. So that is all from me. I appreciate your time today with this fairly brief presentation, and again, feel free to contact me and ask any additional follow-up questions. I will be happy to answer them. I will turn that back over to Christina.
Thank you so much, Brandon, for a great presentation, and thank you to all who participated. The recording and slides will be available within 24 hours or less. Just once again, please join us at the Kennedy Center for a night of networking with over 200 federal contractors. Our quarterly event will take place on Monday, June 20th. Sponsorship opportunities are confirming, and please note that ticket prices increase on June 13th. This concludes our webinar. Thank you so much, everyone.